for immigration purposes, a withhold is considered a conviction. What would you, are you familiar with the immigration consequences of crimes? And if you are, if you're not, is that something that you're gonna make sure the prosecutors know? Because sometimes people getting convicted of crimes cause a lot of consequences.
Yes.
I particularly practice immigration law, and I'll give you an example. I have a client who got arrested for child abuse, no harm. He did have he had a marijuana case from before, but with the child abuse, no harm, it put him in a position where he was subject to deportation. Culturally, a lot of people from the islands, South America, Central America, they spank their children. He really didn't know that he could go to jail for spanking his son, right? So that's a cultural thing that, ignorance of the law is not an excuse, but him getting that conviction literally is going to have him deported, and he's going to lose the right to raise his child. Are you willing to train or allow your prosecutors,
Yes.
if and when you become state attorney, to have some sort of discretion and take those types of consequences into consideration when they're offering plea deals?
Absolutely. I have been doing that since I've been a prosecutor, and I will continue to do that as a prosecutor. And I will instruct my assistant state attorneys to take that into consideration. Now, that means sometimes you have a case and you can resolve it justly and fairly, but in a way that doesn't make the person eligible for deportation. And that's what I'll try to do. I won't give someone special treatment because they may face immigration consequences that I wouldn't give to somebody else just because of that issue, because part of my platform is equal justice for all. So I wouldn't give someone an extra special treatment for that, but I think that in many circumstances, they can be held accountable for the crime that they committed in a fair and just way, but we could still avoid a deportation consequence. So I will absolutely have training on that and instruct my prosecutors to try to resolve cases like that whenever possible. Our job as assistant state attorneys is not to deport people. We don't get paid to do that. That's not in our jurisdiction. That's not what we do. And we have enough work to do than to do someone else's work. That's work to be done by the federal agencies and federal agents. So I'll also instruct our people on that, our state attorneys, in that way. And also, we're not going to try to find out if people have immigration, if they might be deported, what their background is. It's not for us to make people uncomfortable asking that. If it's brought to our attention, if we're told that, we will take that into consideration. But my essays aren't going to go looking for people to find out if they might be deported to try to see if they can deport them. And the same thing goes for witnesses. We don't want witnesses to be afraid that might be something that happened to them, because then they won't come forward and they won't testify.
Absolutely.
Now, imagine you're a victim of a crime or someone in your family, and the only witness that can testify is someone that's afraid to come forward because of immigration consequences. So then you can't get justice because someone's afraid that if they come to tell the truth, that they might be, deported or unfairly targeted.